Okay, I should be on now. So anyway, I'm David Durham. Been in real estate 25 years. I've been with Keller Williams for most of that time. I was in the Round Rock office for 13 years. And then I've been here since December 2015. I had a moment of insanity for a year and 10 months and went to another company. Didn't work for me, because this is family. I think I've told you guys that before. So, and I get to teach, which is what I love to do. So I definitely want you guys to ask questions. If I don't have the answers, we'll get the answers. Obviously, Avis is the queen of the contract, so she has more of the answers, but with 25 years with her experience. So our contracts just continue over time. They get more and more detailed and more helpful as we go. So I'm just going to dive into this. Here's a question I have for you. Right now, the way that you see this on the screen, is this a contract, or would this be an offer if you're filling it out for your buyer? It's an offer. It's never a contract until it's agreed to and has an effective date. Executed, effective, whatever you want to call it. So it's a pet peeve of mine. Agents call me and go, hey, I'm sending you a contract. I'm sorry, I didn't know that all parties had agreed to it yet. It's an offer, but that's just me being very technical. One of the things you'll notice that it says, let's see the pointer here, is this is not for use for condominium transactions. There is a separate agreement for condominiums. Parties, I think it's going to be pretty self-explanatory. You do need to ask the buyers how they want their name to appear. An example that Avis gives, which is a great example, is Bill and Sue Jones, really good friends of hers. Well, he may be William P. Jones, and she may be Susan. So how you know them, you need to ask them, how would you like your names to appear on the contract? Okay, do you have a question?
Well, I was just thinking, does it not have to be their legal name, like what their driver's license would be, or it doesn't?
It doesn't necessarily have to be that way. It's however they want to take title. They want to put their middle initial in, they can. The buyer, just ask them how they want it to appear. Sometimes you may only put his name because he's the only one that's being qualified on the loan. But if he's married, he will his wife will have to sign because it is a community property state. So she'll have to sign the deed at the time of closing.
But nothing beforehand, only the deed, not anything to do with
Nothing beforehand. What I would say is talk to the mortgage officer before you fill it out if you think that there's a chance that only one party is going to be qualified, because the mortgage company will probably only want that person for who they're qualifying on the offer. The seller name you'll get from Real List. Do you know what Real List is? Okay. Real List is the tax records that you go into our MLS, and there's a place that says Real List. It's a tab. It is the more detailed of our tax records versus going to TCAT, Texas Travis County Appraisal District, or WCAD. Those records are not as detailed. What you can see on the Real List is every time that it's sold, possibly what it's sold for, how much the buyer's mortgage was for, so on and so forth. There's a lot more details in there. So that's where you're going to get the seller's name per the tax records. If that is not correct, then the seller and their agent should correct that. Seller agrees to convey the property. Seller and convey to buyer, and buyer agrees to pay seller for the property defined below. So you're getting into paragraph 2, which is about the property and the legal description. Again, this is on the MLS, but I would then verify it with the tax records to make sure. Because sometimes an agent might fill in everything manually and not auto-populate the tax records. The tax records is what I would go off of unless the agent is given some note. So your lot, your block, subdivision, what city it's in, what county it's in. And then guys, make sure that when it says here, known as, see right there, address and zip code. Make sure you put the zip code in there. Let's move down to improvements. Basically, 2B and C are that everything attached to the property is to stay unless otherwise stated by the seller. What kind of things can those be that a buyer possibly could take, I mean, a seller could possibly take with them?
Curtain rods. Curtain rods.
Curtain rods, okay? Because curtain rods are attached. How about the curtains? Curtains, if the seller wants them, then the seller has to put down that they do not convey, which is in D right here. But you'll see things here like all the equipment and the appliances, the valance, the screens, the shutters, the awnings, TV brackets. They have to, if they have a flat screen TV and it's got a bracket, they need to go ahead and leave the bracket unless they're willing to pull it down before you get it listed, patch the holes, and paint that area. Heaters, speaker brackets, security, chandeliers, water softeners, all that. Some people want to take their water softeners, so if the seller wants to take it, they would write it right here. And the buyer has to be agreeable to that. Garage door openers, cleaning equipment, please leave the shrubbery and leave the landscape. There are people that, I mean, we would have possibly in a former house of ours pulled a rose bush that we had been given in memory. We decided not to do that, but we could have asked the buyer and we could have put it in there as that it was going to be excluded. The most important part, well, there's not a most important part. Never mind. So if all property owned by the seller and attached to the above described property. So do pictures, are they personal property or are they chattel? Personal property. Furniture is chattel. It's not real property. It goes with them. It's those things attached to the wall. If you see a shelf that is, just like a mantle-looking shelf, and it's attached to the wall, if the seller wants to take it, they probably need to pull it down before they list it. But if it's up there, at the time that your buyer puts an offer on the property, if the seller doesn't specify right there, then it should go. Yes?
I heard something interesting in one of Candy Cook's classes, that stove, if it didn't have the anti-tip connecting it to the wall, then they could take it.
I would.
I mean, they could, not that people really would.
Yeah,
But it is an
they just need to put in, we just know that refrigerators, washer and dryers, we know are chattel, personal property, and go. Some people leave them. If they do, that's great. But I don't see stoves typically being taken, freestanding ranges, to be technically correct.
I was shocked to hear.
Yeah.
So, okay. Reservations, any reservations for oil and gas or other materials, timber, water, all of that, oil, gas, yeah, all those things. You actually there's a special addendum for that. You're going to notice that there's addendums, guys, all over the place. So you've got an attached addendum right there for relating to minerals on the property. I have run into one time in my 25 years of somebody actually owning, the seller owning 100% of their minerals. I'd never have seen that in my life. And what this guy had to go through and the money that he had to pay to get all of this, because you have to go back into the 1800s. Pretty amazing. Okay. Paragraph 3. So the first part of that is the down payment that they're putting down. Where do you get that from? You get it from the buyer or you get it from the mortgage company. How much are you putting down? That's the question that you ask. The second one is their loan. Again, we've got all kinds of addendums here. So if they're doing third-party finance, FHA, VA conventional, then they would check the first one. If they're doing an assumption, loan assumption addendum, guys, I have not seen one in ages. Back in the mid-1980s, they were doing loans that could be assumed from the mortgage company. I just don't see that anymore, but there are some out there that periodically will pop up. And then seller financing, there is a separate addendum for that. Have any of you guys run into seller financing? Look at the form and know what it says. Because you got to know interest rate, you got to know how long it's going to be amortized for, and such. And then 3A, 3B, add it together, should equal 3C, which is the sales price of the house. Any questions on that? Please.
I would say I've never seen loan assumption or seller financing. Almost everything's.
Yeah. Most of it that you're going to deal with is going to be just that first one. I've never done a loan assumption, but I have done seller financing.
Oh, okay.
I have. So they're few and far between if someone's got their house paid off. It's a great way for a seller to make some money in addition.
And seller financing is different than lease purchase.
That is correct. If you ever have somebody that wants to do a lease purchase, send them to an attorney.
Right.
Seriously, and Avis will tell you that. Send them to an attorney because there are so many things involved in that. Does a portion of their monthly payment go into the principal, and all of that? How much money are they putting down? What's going to happen with that money if the people don't close or if they do close? So on and so forth. So I would say, and Avis will back me up, right, Avis? That an attorney needs to be hired to write that up.
David?
Yes.
I had someone recently ask me to do one of those,
Mm-hmm.
and I referred them to an agent outside that was willing to do that kind of work, but it's risky.
It is very risky. Very, very risky. I wouldn't want that liability. So I think you did the right thing on that. Okay. Number 4, if you are the buyer of this property that you're doing this offer on, you're a real estate agent, you do have to disclose it. If you are 10%, or more than 10% of a business entity, you need to disclose that you're a real estate agent. If you are part of a trust, whether it's held by the spouse, the parents, the child, and they're the beneficiary, you have to notify the parties that you're a real estate agent. Okay? Earnest money. Typically what I see myself is about 1% of whatever the sales price of the house is. So your amount goes right there. Your title company goes here. Oh, you know where this pet peeve's going, don't you?
Yeah.
What is that pet peeve?
Not somebody's name.
Not somebody's name. Don't put ABC Title Company dash Monica Smith. Leave the Monica Smith out. You guys take care of that when you turn it in, but it's to a title company there. And then the address of where they're at. This is really important. I do see times where it just says, the title company doesn't have an address. Well, I'm going to go turn it in where I want to if I'm working with the buyer. But the agent may have had a preference of where they would have wanted it. So just make sure that's filled in. If there's any additional earnest money to be put in, I personally don't see this much at all. But where you may have a situation like this is in a backup contract. Someone's got a backup contract this is a backup contract, and they're going to run this, say maybe at $500 or $100, but in 30 days they'll put an additional $1,000 down. That's acceptable.
We just did it on a contingency.
Tell me about that.
I can't because my team did it, but I didn't personally do it.
Okay. So on a contingency, so they had a house to sell, so they put an amount of money down, in a number of days they'll put an additional amount of money down. If buyer fails to...
Be after the effective date, so if it does not,
That's correct.
you can't just say 30 days from now, I'm gonna give you more money, earnest money. It has to be so many days after the effective date.
That is
So
correct. It's
exactly
everything,
correct.
everything is after the effective date, guys. Everything is determined by that day. And your effective date time is not business days, it's calendar days.
So in the case of the backup contract, you still wouldn't give any money until it's effective, until it's executed as first place now.
That is correct. I would give probably would give a little bit, but then later I would give, then have the buyer recommend that the buyer give more. Is earnest money required for a contract?
No.
These used to be called earnest money contracts. You'll notice at the top, they are no longer earnest money contracts. The word's been pulled out. You don't have to give consideration to do the contract. Okay, so seller may terminate the contract or exercise seller's remedies under paragraph 15, which is the default provision, or both by providing notice to the buyer before buyer delivers the earnest money if they don't get it in within this time right here. Because the buyer would be in default. If the last day to deliver the earnest money falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest money is extended to the end of the next day that is not a Saturday, Sunday, or a holiday. So if you've got Saturday, Sunday, and then Monday's a holiday, then you have to have the earnest money in by Tuesday. Says time is of the essence on this paragraph. What can a buyer do if that earnest money does not show up? What can a seller do if the earnest money does not show up?
Walk away.
Hmm?
I mean, they're done. And you got 3 days. So after effective.
Title policy. The title policy in the state of Texas typically is covered by the seller. That's the norm. So most of the time, but it is completely negotiable. When might you see it as a negotiable item?
If they suggest they want to sell at, or close at a different title company, is that right?
Could be.
If you're in a multiple offer situation, if you're the buyer and you really want the house, you can offer to pay
Very much so.
the title.
Yes. Yeah. And where the title company is, again, is not locked in. It's not you telling your buyer it's got to be at this title company. It can be the buyer says, well, I've got a family member that works at ABC Title. And if the seller is fine with that, that's great. But the seller could cross through it, and that can be actually a counter to the offer.
So what if we have a listing, we've already opened title for that listing, and come contract time, the buyer chooses a different title company and it's a bone of contention? Do we just say, I'm sorry to the title company that we've opened title with?
Yep,
Okay.
you do. Yeah. Title companies would not like me. I mean, if your buyers are willing to have you fight for that, then do it. But if it's your preference, you've opened the title, the buyer didn't know about it, whatever, you might just want to
It's
go.
never the buyer and the seller, it's always the agents. I mean, very rarely.
Now you tell me.
Rarely is it the actual buyer.
Because do the buyers and sellers typically know anything about a title company? They don't. Who did they ask? Yeah, they usually ask us. Okay, so this is the title policy, title commitment, and who's going to issue it? It is typically, so you can have earnest money held at an attorney's office. And the attorney may have a relationship with ABC Title, and ABC Title will be the one that runs it. If you go to Capital, Capital's holding the earnest money. T&T is not going to run the title commitment if they're probably not holding the earnest money. It just doesn't make sense to do that. So these typically are going to line up. So the title company there, the title company here, unless it's an attorney, and then you need to call the attorney and say, what company do you use on your title policies, so that you know what company to put in there. Very rarely run into that, because usually the attorneys, you already know who they're working with. Okay, so so it'll be issued by such and such title company in the amount of the sales price dated at or after closing, ensuring the buyer against loss under provisions of the title policy, subject to the promulgated exclusions, including existing buildings, zoning, and the following exceptions. And then there's this list of exceptions here. Restrictive covenants, standard printed exceptions for standby fees, taxes, and assessments. Standby fees, taxes, and assessments I see in municipal utility districts. Those are in there. Liens created by the financing, utility easements that were created in the past. You'll always, the most important place to look on a title commitment is Schedule C. Schedule B is important too. The Schedule C is where you guys are looking and reviewing to make sure that there are no problems. For example, I had one here recently that the owner had a judgment that they were not aware of attached to their house. So we either had to get that cleared. Title company wasn't going to let us close, so the buyer didn't need to send us anything in writing saying you need to get this cleared up, because it wouldn't have closed otherwise. Anyway, my client had to pay the $666 for the judgment that was attached to his house. Okay. Standard printing exceptions for discrepancies, conflicts, shortages in areas or boundary lines, encroachments, intrusions, overlapping improvements, which then goes right into this. Oop. I got most of it highlighted. So this has to do with the survey and whether the survey will be part of the title policy. If there's any shortages, discrepancies, boundary lines, encroachments that show up in the future, I would say you, as a buyer's agent, you always want to check this. You've probably never heard this. Our surveyor's perfect. Do they make mistakes? Yes. In all possibility, I will advise my buyers that they might want to go ahead and get their own survey or ask the seller to pay for a new survey, even though the seller has already given us one, because there can be mistakes. I will tell you, my buyers don't want to do that. They want to save $450. And by having this wording in here, so number one is it will be amended or will not be amended or deleted from the title policy, or it will be amended to reach shortages in the area at the expense of either the buyer or the seller.
So that's the one we check?
That's the one I would check as number two.
Number two? Okay.
Number two. Yes. And then you check buyer or seller. I believe that this cost 5% of whatever the title policy amount is. So if it's $2,000, yeah, it's not much money. You're in a multiple offer situation, maybe you check the buyer on that. Just another thing to help if you're in that multiple offer situation.
So, can I ask you?
Yes,
The survey is the one that you get at 247, right?
yes, it is. And we're going to go over that
Okay,
in detail.
okay.
So
Slow down.
hang with me. The commitment must arrive within 20 days from the effective date of the contract to the buyer and or their agent. Do you guys mind if I just jump ahead just for a second? Because I want to nail this while I can. When you guys get to this, please, when you're on the buyer's end, never, never, ever put your contact information in there. That means you will receive all notices, the title commitment, everything that the title company, the HOA documents are all going to come to you. Do you want to be responsible for having to get that? Let it go straight to the buyer. Same thing with the seller. I see agents periodically go in here and fill their name in here and then fill the other agent's name in here. Well, we don't want the stuff. We want a copy of it, yes, and the title company will CC us on it.
I had just recently, a listing agent that did not put that in, they just left it blank. So where does that,
I
where did this go?
just give them a nice courtesy call or email and just say, hey, you might want to make sure you get this in so your clients get it. But it's not your responsibility. The title company, not that it's their responsibility, will probably call that other agent up and say, who do we send this stuff to? Oh, what happened? Oh, I didn't know I could move this with this. Okay, so let's go back to commitment. So 20 days for them to get the title commitment. It consists of Schedule A, B, and C. C is what I find the most important, not that B and A are important, but you just want to read through. There are standard things on there, like there will be a Upper Brushy Creek Control and Improvement District notice signed at the time of closing. There'll be a release of lien, affidavit of debts and liens that they'll have to sign at closing. There'll have to be a marital status that they have to sign at closing. Those are just clearing those little things up that are on the title commitment. So they get it in 20 days. So it says, receives a copy of the contract, seller shall furnish to buyer a commitment for title insurance at buyer's expense. Eligible copies of restrictive covenants, documents, evidencing exceptions, blah, 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 blah. Seller authorizes the title company to deliver the commitment to the address in paragraph 21. Commitment exception documents are not delivered, it automatically extends for 15 days. It's already built in there. So it's extended up to 15 days or 3 days before closing, whichever is earlier. If the commitment and exception documents are not delivered within the time required, buyer may terminate this contract and earnest money will be refunded to the buyer. Who is, on a 1 to 4 family residential contract, what is that contract, what party is it written most for? The buyer. There's over 30 outs
30-some ounce.
to get out. How many are there for a seller? Very few. Very, very few. So you have to make sure, have your checklist. If you want a checklist, I have checklist that says on this date the title commitment was sent to the buyer, or if we're on the seller, so that we know, and we're reviewing Schedule B and C, and we're making note of all that to make sure that we're staying on time frame with this contract. Survey. I love the survey one. Okay, survey must be made by a registered professional land surveyor or acceptable to the title company and to the buyer's lender. The next 3 boxes, box number 1 talks about if you're asking the seller to furnish to you an existing survey, and what else? What if you only get the survey? What happens? If you only get the survey and not the T47, per the wording here, if seller fails to furnish the existing survey, or, I don't know why it doesn't say and, affidavit within the time prescribed, buyer shall obtain a survey at the seller's expense. Whose job is it to get you the survey within time of that paragraph? The seller and their agent. Who is responsible to get you the T47? Same thing. Is it your job, if you're working with the buyer, to call that seller's agent, that listing agent up and ask for that? No. Please do not do that. Avis can shoot me later if she thinks that's wrong. But that is working against your buyer, because your buyer may have an out and they could have possibly gotten a new survey. And if they found out that you called, I don't want to be involved in that. Okay? If an existing survey is needed, then, and that is if the lender or the title company needs a new one. Guys, I've never had one yet in all the years that this has been going on. But it could happen to you, it could happen to me. Then we're checking, is at the buyer's expense of that $450 to $500. Surveys can be more expensive if they're on acreage and they're really treed. So you guys need to have a talk with your buyer on, do we have the seller pay for it or the buyer pay for it? We're in multiple offers, maybe we have the buyer pay for it. And that has to be done 3 days prior to closing. So I'm not going to call an agent. If you get a T47 is an affidavit, and an affidavit by its term has to be signed and notarized in front of a notary. So you may receive a T47 with only the information, but it's not notarized. It doesn't fly. We had one recently that the agent kept saying, the title company will take care of that at closing. The title company will take care of that at closing. They just sent us the T47 with no notarization. And I told my buyers, I said, you have the right at the seller's expense to have a new survey done, because they did not get the information they were required to. My buyer said, we're not worried about it. So, but just know.
Did you get that in writing?
But that could get expensive if you're talking big acreage.
It can get expensive. Oh, yeah.
And that's probably where you'd run into that, would be acreage farther out of the city type scape, if you will. Just because
Right.
when surveys used to be done with chains.
Yes. When George Washington was around, it was a string, but it was chains.
Yeah.
So the next one is if you don't check this one, or if the listing agent and their seller changes it to buyer shall obtain a survey within so many days from the effective date, that's what that's for. Or if this box is checked, which is it's at the seller's expense within so many days from the effective date, that they should obtain that survey. Any questions? I see the wheels turning, I think, here.
So if you have the buyer or the seller obtaining a new survey, it still has to be approved by the title company.
That is correct.
And is there a certain number of days? Like,
No.
I wouldn't know what number of days to put in
Well, here's
2
the,
and 3.
yeah, so the title company, really what it gets down to is if there's any objections to the survey or the title commitment, this is the paragraph that you're looking at, that you have to put it in writing. 25 years, I've never done this.
Okay.
Not saying you won't, but it would be put it in writing. It would be, buyer must object the earlier of the closing date or so many days after the buyer receives those documents.
That's the buyer, that's not the title.
That's the buyer. The title company, I will tell you, most of the time the title company's ordering these for us, so they're getting it firsthand, and
Okay.
I mean, they can review it on site. Seller shall cure anything that's in writing that the buyer put in writing, of anything that needs to be done, that they will take care of it within 15 days after seller receives the objection, which is called the cure period, and the closing date can be extended. Again, guys, I never have had to deal with this. Chance I think that'll happen to you is probably pretty slim. E1, abstract to title policy. Basically what this paragraph says is that if they're not getting a title policy, they need to get an abstract and they need to get an attorney to review all of that. So it's not a title, they're not getting a title commitment. But we're recommending that the title be researched and that they have an attorney look over it. And that's what that paragraph is about. And again, it says, if the title policy is furnished, the commitment shall be promptly reviewed by an attorney. They're saying it can be reviewed as well. I don't see that most people do that, but the wording's there. But an abstract, definitely, because that gets out of our realm of such. Membership in a homeowners association. So, on the MLS, it typically states if it's in a homeowners association. And as you guys are in business, as long as like Greg has been in business, you're going to start to know which ones are an HOA and which ones are not. But it's listed on the MLS. You need to verify it to make sure. There was one here recently, I believe Sarah did it, that I think it said that it wasn't an HOA, but it actually was not an HOA. It was checked on the contract that way. But we found out there was no HOA because we went based upon what the MLS said. And then it was, no HOA. Client didn't care. But there is a form for that. What this form is basically saying, the addendum for the property subject to mandatory homeowners association, is that within so many days from the effective date of the contract, that the seller at either the seller or buyer's expenses to get a copy of all the covenants, restrictions, bylaws to the buyer and their agent, and a resale certificate, which is filled out by the HOA or their management company. Resale certificate contains information including but not limited to statements specifying the amount, the frequency of regular assessments, the style and cause number of any lawsuits which the homeowners association may be in, or other lawsuits relating to unpaid ad valorem taxes of an individual member of the association. The buyer, if the buyer is concerned about these matters, the TREC promulgated addendum for property subject to mandatory homeowners association shall be used.
So you don't have to? Use that?
I would say you always have to if it's an HOA.
Yeah.
Because you need to know, you don't want to get into something where there's a lawsuit. Hester's Crossing Homeowners Association was in a lawsuit some years ago. It was a condo complex. Because in that particular area in Round Rock, the condos were really starting to have foundation movements. And so they weren't getting them fixed. There was, I don't know all the details, but there was a lawsuit. So I had a buyer who was putting an offer on one. I had explained it to him. And once he got the documents that stated about the lawsuit and how long it had been going on and so on and so forth, and he did research, he was like, because I don't know that the HOA is going to be around. Kind of a worst case scenario.
David, where it says you are obligated to pay assessments a little higher there in bold,
Yes,
is that just a notice to
That-
you're in an HOA?
that's
or-
just a notice. If you don't pay your HOA dues, they can foreclose on your house.
Right, okay, so it's not directed towards the buyer or the seller, it's just a notice.
It's just a notice.
What about special assessments? Am I getting way ahead of you?
It's right here in front of me.
Okay.
It's here. We'll get to it.
Okay.
I like to call number 3 here, water statutory district. It just says statutory tax districts. Guys, this has to do with any water-related things, sewer, sewage, flood facilities. A municipal home in a municipal utility district. This notice, and by the way, it has to be. Seller is required to deliver to buyer to sign this. There's a particular thing I'm looking for, and I'm missing it.
It's the mud notice, isn't it?
Yeah, it is the mud notice for that mud. You can get those from the title company if need be. It is also when you look on, and how do you find if it's in a mud? If you pull Real List up and you see the taxes, it lists the entities that are taxing, and you see Williamson County Mud District number 10. It's in a mud. Municipal Utility District is what that stands for. Another one you will see in a lot of Williamson County, not all of it, but most of it, is the Upper Brushy Creek Control and Improvement District. It assesses 2 cents per $100 of assessed value. And because it has to deal with water and it deals with dams, it has to be disclosed.
David,
Yes.
is having those 2 notices in the documents and the listing considered delivering, or should we ask?
It is considered delivering, but I would go ahead, once you get an offer, to go ahead and send it to them just to not cause any problems.
To the buyer's agent?
Yes. Yeah. If you go again and ask for, you're working for the buyer and you say, hey, Mr. or Mrs. Listing Agent, I need to get the municipal utility district notice. Don't do that. Don't ask for it. It's their job to get this information to you.
And that's funny because I did a contract early on and the listing agent told me that make sure you provide the mud notice and with your offer. Make sure you've got your,
But you were on the buyer's end.
yeah,
He was just saying, pull it down from the MLS and go ahead and get your clients to sign
it
it.
wasn't in the MLS.
Oh.
I had to go and find it.
Oh, well, you didn't have to.
Okay.
It is, guys, again, it says requires seller to deliver and buyer to sign the statutory notice of indebtedness standby fees for this district. And let me notice the very last words, which is what I was looking for. It was right there in front of my eyes. Prior to final execution of this contract. What happens if an agent sends it to you, these notices, a week later? They are in default per this. Did I say that? If the listing agent doesn't get it to you in time, you could be in default, that agent could be in default.
So when you are going to submit an offer, do you ask them, if it's not in the, which they hardly ever are, in the documents in the MLS, do you ask them to send it to you?
No, I do not. The only thing I ask for, if the seller, if the buyer is asking to look at the seller's disclosure notice beforehand, I will ask for that. But these other documents I do not ask for. I do notify my buyers, and I will show them through a list. Your home is situated in a municipal utility district. Your home is situated in the Upper Brushy Creek Control and Improvement District. I'm letting you know. It's to the point that you could go ahead and have them fill out that form and just have them sign in. You're just kind of stashing that away, that you gave them notice. But it is the seller is responsible to get that to the buyer within the days specified for this contract.
So you don't let the listing agent know when you're about to execute the contract and they haven't supplied them, then you just don't say a thing.
Nope. Because again, if I go ask for it, and if my client somehow found out that I asked for it, now you want the deal to close, I get that. But I'm also on this line of, oh, if I take something away from the buyer of being able to get out, say they lose their job, there's other circumstances, not the best circumstance to give, but if something happens, there's all kinds of ways for the buyer to get out. Sorry, we didn't get the Water Control and Improvement District notice, we're out of here.
So will it go to closing without it?
Yes, it will go to closing without it, because at closing, they're signing all those documents again. They'll sign a T-47 all over again if it's an existing survey. They will sign anything that's in a municipal utility district, that notice, and in an Upper Brush Creek Control and Improvement District or like kind. Tidewaters, we don't live on the coast, so we don't have a lot of that to deal with. Annexation, if the property is located outside the limits of a municipality, which all municipal utility districts are, seller notifies buyer under property code that the property may now or later be included in an ETJ of the municipality and may now or later be subject to annexation by that municipality. So, one of the things when you're doing this offer for your buyer, you're also having them sign a general information which talks about annexation. If they're worried about it, they need to do their research. Okay. Now, if it's in the process of being annexed, I believe you do have to give some kind of notice. They're in the works of annexing. If Austin's annexing something, I believe you have to give notice on that. Property located in a certified service area of a utility service provider. It does talk about water and sewer services to this property. You need to contact the utility service provider to determine the cost required to pay and the period, if any, that is required to provide water sewage service to that property. Public improvement districts. If the property is in a PID, the seller, it requires the seller to notify the buyer as follows for those things. Transfer fee. There must be some case that there must be some transfer fee somewhere. I don't know where it is. So I don't have a whole lot of knowledge on this because we don't have transfer fees. The legislature over the years has tried to get transfer fees for real estate implemented, passed into law. But it's gotten, thankfully, TAR has really been fighting that fight for us so that we don't have to pay transaction fee. Nancy, do you have that bewildered look?
Oh, I was reading it.
Okay.
Well, there's no blank to put anything in there anyway.
No, there's not. Propane gas system service area. I've run into this once in Leander. What this is not the propane tank on the single home that's in a subdivision. This is a community-operated propane tank to the houses. In this subdivision, there is a notice for this. There's another addendum. So you got to just think about all the addendums you got to have. But this is a community tank. You're paying for the gas that you use, so on and so forth.
There's a neighborhood hut on it also.
Well, do you know what neighborhood that is? Because I can't think of the neighborhood in Leander either. It's off of Baghdad Road.
Yeah, I'm trying to remember.
Austin's Colony has one.
Austin's Colony?
I'm
Mm-hmm.
not sure.
So there are those out there, and you need to give notice. And again, this is seller must give buyer the written required notice. Required by 141.000 of the Texas Code. Notice of water level fluctuations. So this is relatively new. And because of the drought that we had had in the past, and the lakes got so incredibly low, I would see docks hanging on the sides, you know, with not even in the water. I'd see boats sitting up on land. They were seriously dry docked and such. And so that's what this is covering. It's for a capacity of at least 5,000 acres, feet. The water level of the impoundment of the water adjoining the property fluctuate for various reasons, including as a result of lawfully exercising its right to use the water stored in the impoundment, drinking water, whatever, drought or flood conditions. So it can fluctuate either way. Because I believe, can't tell you where it was, I believe there was actually a lawsuit for someone who bought a property on a lake, the water level went down, and I think they tried to sue the buyer. Go figure. Property condition. I'm going to jump right down to here. So the seller's disclosure notice, if you've received it, if it's on the MLS, this is the box you would check. If you haven't received it, then you're going to check 7B2 right here. And you're going to put how many days you want to have the seller and their agent get that seller's disclosure notice to you guys. And then the buyer has 7 days to review it after that.
What's a typical number you would put in there? 3 days?
Me, I put 3 days.
Okay.
Yeah, I put 3 days. So, so they've not received the seller's disclosure notice that they'll, within 3 days from the effective date of this contract, seller shall furnish the notice to the buyer. If buyer does not receive the notice, buyer may terminate the contract at any time prior to closing, and the earnest money will be refunded. If the seller delivers, buyer may terminate the contract for any reason within 7 days after they've received the seller's disclosure notice.
Even outside of the option period.
Even outside the option period. If your buyers do not ask for the seller's disclosure notice, do you ask for it?
No.
I would not ask for it.
Okay.
Well,
So basically-
you know what? I'm straddled the fence on that because I need to know if there's anything up with the property. So take back what I just said. I do.
You get an inspection though, right? So you
You do get an inspection, but if there's been any previous flooding, that the inspection would never probably state unless there was still water damage or insurance claim or anything like that. I do want my,
People want to see that.
they do. I mean, most of the time they do want to see it beforehand. Or the property is not required to, the seller is not required to furnish the seller's disclosure notice. An estate is a really good example. An investment property. Any others you can think of? Land? That is correct. You would not use this contract. Okay. On 8D, 1 and 2. Buyer accepts the property in its present condition, or the buyer accepts it with the seller doing, at their expense, these items. It says, do not insert the general phrase such as subject to inspection. If you happen to see it, if you're on the listing end, cross it out. Get everybody to initial that, because it should not be in there. But that is, you know, that can be a myriad of things that are on there. As I tell all buyers, because usually one is the one that's checked, I tell them, I'm checking this, but give me time and we're going to get to paragraph 23, which actually trumps this. Okay, but this is if you really want to make sure maybe there's something really big, the shingles need to be replaced or something, you want to go ahead and put it in there and see if the sellers will accept it before you get into the expense of the inspection, so on and so forth. And that's why you would put that in there. Lynn?
That's just stuff you see on your first, when you go look at the home that is obvious is what you.
That is correct. Or if the seller's disclosure notice would have to state something. Like, for example, the seller's disclosure notice states, and I think you kind of mentioned it, there's been an insurance claim on the roof, but the people just pocketed the money. And have I had that happen? Yes. So I probably would put shingles to be, I probably would put roof shingles in there, because that's a big item. Lender required repairs unless otherwise agreed to in writing. Neither party is obligated to pay for lender required repairs. It's negotiable. But if the seller says, I'm not paying for them, the buyer can walk. And there's also a provision in here that if the treatments and repairs exceed 5% of the seller of the sales price, the buyer can walk.
So in that case, if you had something, an incident like that where the roof was not replaced,
Mm-hmm.
and it has to be for the lender, they can be pretty costly. The buyer could walk very easily.
The buyer can walk in either case. If the seller's not willing to take care of it, they can walk. I'm starting to think that my class wasn't good enough and you left. Ooh. Completion of repairs. The repairs need to be completed prior to closing. It also states in here, it also says, and I want to make this point right here. Any transferable warranties received by the seller with respect to repairs and treatments will be transferred to the buyer at the buyer's expense. So I want you to know that. If seller fails to complete any of the agreed repairs treatments prior to closing, buyer may exercise the remedies under paragraph 15 or extend the date by 5 days if necessary for the seller to complete the treatment and repairs. What I typically like to do is I typically like to see an exchange of money in lieu of repairs. Doesn't work in all circumstances. You have a single mom that just doesn't know what to do, doesn't have the time, she's working, she's taking care of the kids, then maybe you're asking the seller to do that. But a lot of times either a reduction of the price or adding into paragraph 12A1B, which I'll get into here that have some amount of money. We have one right now that the inspection report came in. The seller, the buyer estimated there was about $6,000 worth of work that needed to be done for the house per the inspection report. And so we did a counter on that to $4,100 and said we'll pay that $4,100 in lieu of doing the repairs. The reason that I like that personally is because I'm not depending on the seller. When I'm working with the buyer to mess something up, I'd rather have the buyer do it the way they want it done and let them hire and take that responsibility on. I had one here recently. You guys have heard this story a little bit. Some of you have. We had a house that was closing. It was my next door neighbor's. It had been inspected. We had done all the repairs per the amendment. The day of closing, my client goes in, the sellers, and sign all their documents at the title company. At the time that the buyer and their agent's supposed to be at their closing, they're at the house with a repair guy. They came back to us with an email and said, we've had someone look at the house, we're past the option, we've agreed to repairs, we've done the repair satisfactory, and we've produced invoices even though they didn't ask for them. And the buyer's agent put in writing that the buyer wants $15,000 or the buyer will terminate the contract. Well, the buyer could not terminate the contract. My client and I discussed it, and I said, let's just let him go. Because they're just going to be this is just a problem, and we're just not going there. It wasn't worth it. I was never so happy to put a house back on the market in my life. And we, it headed to court. It's just not worth it. So we ended up just giving them their earnest money back. Even though my client had every right to keep that money. It was just like, be gone. Be gone.
More money for it anyway.
And we did.
Yeah.
And we did. And we got more money for it.
Yeah.
So, you know, things like that happen.
Check your ego in that situation.
You do. I had a client one time, I was on the seller end. They did the repairs that were asked of them. They repainted this column. They replaced the rotten wood. But the paint didn't match exactly because it had weather and so on and so forth. Well, the buyer just raised all kinds of cane because the paint was slightly different. And I had a seller that was just, he was feisty. Let me just put it that way. And he just said, they can go bye-bye. We'll put the house back on the market over mismatched paint. This is the reason that I like to have money exchanged in lieu of repairs, so that we don't have to deal with that.
It's always a nightmare.
Yeah, it doesn't happen very often, but this was just one of those cases that I remember, and I thought, I'm doing money from now on, as much as we can.
Do it right now on a foundation, you know, it doesn't have to be repaired prior to, but we're just doing the exchange at the end.
There you go. Okay, so I think we pretty well covered that. If there are any environmental concerns, the buyer is advised that the presence of any wetlands, toxic, asbestos, waste, environmental hazards that may, or endangered species, or its habitat may affect buyer's intentional use. The buyer, if they're concerned with these, there is an addendum promulgated by TREC. Residential service contract. Who can explain to me what a residential service contract is?
Home warranty, right?
What's that?
Well, is it just a warranty, home warranty?
Home warranty, okay. So what it does is it covers typically the mechanics of the house, it covers the plumbing, it covers the electrical. It does not cover things like the shingles. It doesn't cover things like the refrigerator because that's a personal item, or washer and dryer. But each policy is different. And so what this is saying is that by putting an amount here, the buyer may purchase the residential service contract of a company that's licensed by Trek. You can go on their website and it lists all of the service, the residential service contract companies. I send that list to my clients and I say, here's your choices. It's like 100 of them. So that they can choose, because everything can be different. How long things are covered, when will the policy go into effect, how much is the service call, so on and so forth. So it says basically it's the buyer's choice to choose this, and the seller will reimburse whatever this amount is right here. Buyer shall review any residential service contract, scope of coverage, exclusions, limitations. This policy is optional. So you're in multiple offer situation. You don't have to put anything in here. But I would still recommend that my buyers pay for a residential service contract.
So since they're licensed by Trek, do you file complaints with Trek for those companies?
I believe so, yeah.
Okay, and they'd have to go investigate?
Yeah. I will tell you, always know who the marketing reps are for these companies. Get to know them, because if you have a client that calls you out and goes ABC, and I hope there's not an ABC service warranty contract company, but if there was, and if I know that marketing person really well and my client is really having an issue with them, I can call the marketing director and say, is there any way I can get your help on this? They may or may not do it, but at least I have that contact. So it's good to know these people like Amber, and names are slipping right now, but that's something that, can help. Broker fee. All obligations of the parties for the agreement of broker's fees are contained in a separate agreement. It's not part of the contract. And where is that separate agreement?
Listing agreement.
It's actually in the last page of this. Right there. But it's also through the MLS as well, because the MLS is an agreement that we have via the listing agreement. But this is obviously where you're putting your stuff. You're putting the percentage of the sales price. Where was I at? Separate agreement. Closing date. So the property should close on or before such and such date, or within 7 days after objections made under paragraph 6D, which pertain to the survey title, the survey title commitment, have been cured or waived, whatever day is later. If either party fails to close for the sale by the closing date, the non-defaulting party may exercise the remedies contained in paragraph 15. You didn't perform, we can take you to court. At closing, there should be a warranty deed, general warranty deed, conveying the property over. Seller shall pay the sales price in good funds. There should be all executed notices, statements, and certifications, affidavits, blah, 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 blah. That there are no liens. There's always, usually there's going to be a lien, but it'll be paid off. Seller's got a lien, it'll get paid off. But there's no other liens other than that. There's a document that the seller signs on that. Here's one. If it's an investment property, number 5, if the property is subject to residential lease, if it's a leased property, on a home that's got a tenant in it with the lease agreement, you cannot just kick them out when you buy the house. The lease stays with the house, not with the person, the seller, I mean. It stays with the property. So this says that the seller will transfer the security deposits, if any, to the buyer, and also shall deliver to the tenant a signed statement acknowledging that the buyer has acquired the property and is responsible for the return of those deposits. So it's the buyer's responsibility to do this to the tenant. If they don't and they keep shipping the payments to the seller, there probably could be an issue there. Possession. Buyer will take possession upon either closing and funding or in accordance with the temporary lease promulgated by TREC. Says consult your insurance agent prior to the change of ownership and possession because insurance company coverage may be limited or terminated. If a seller moves out of their house before the closing date, they really need to call their insurance company and let them know that they've moved out. There's no furniture, no nothing in there. Because if the house were to flood in there and the insurance adjuster goes in there and sees there's no furniture and stuff in there, I have heard, I can't verify it, that insurance company would not cover the damages because it was not occupied. It was vacant. So it's a very simple phone call to their insurance agent. As it says, absent of written lease or inappropriate or appropriate insurance cover may expose the parties to economic loss. Leases, basically, that the seller will not execute any leases for renting the property or any material leases once this has gone into effect. Special provisions. I can't ever think of a time that you'd ever write anything in there. If anything's written in there, it should be by an attorney or by your client. You've heard that how many times? 300. Okay. Do you guys want to take a little bit of a break? Why don't you guys go take a 10-minute break and then we'll get through the rest of this. Okay?
When we come back, can we review who pays for surveys again at the
Yes.
end?
Yes. There it is. I believe we were on expenses here.
Just finished special provisions, right?
What's that?
We just finished.
We did special provisions. Do you guys have any question on possession? A buyer cannot take possession of a property until it's closed and funded. Funded means when all of the documents that the buyer signed and the seller signed have been given over to the mortgage company has said that signatures are all there, release funds. And that can be at table, or that can be the next business day. The buyer cannot move in unless agreed to in a temporary lease.
Close late on Friday, maybe Monday.
It may be Monday before they can get moved in. You are never, as a buyer's agent, to turn keys over to the buyer. They stay at the title company. Settlement expenses. You'll see that the seller has things they have to pay for here, right there. Also, paragraph 12A1B is if the buyer is asking the seller to pay for the buyer's closing cost, this is where it goes. No, don't do that. That's where it goes. Where do you get that amount from? Mortgage company. Is where you would get this amount from. And please understand that it says that the seller will pay up to. Doesn't mean that, say this is $6,000, doesn't mean that if the buyer's closing costs are $4,500, that the buyer's going to get a $1,500 difference. They are not. It says up to, not to exceed that amount.
David, can you also use that line for repairs, in lieu of repairs?
Yeah, this is the line I use in lieu of repairs if there's not an amount here. Now, if there's an amount in the beginning, you may not be able to put it here, and you may have to do the repairs.
And there's no way to do an amendment to cover the cost of repairs. There's nowhere to put that amount anyplace else.
No, there is no other, because there's forms being signed that there's no money being exchanged, basically. There's no written or oral agreements other than those stated in the loan documents.
Is that only used in a buyer's market, pretty much, for you to ask the seller?
Yes, yeah, pretty much. I can't tell you the last time I saw this.
I did it once, maybe 4 years ago.
Yeah.
Yeah.
So you've seen it one time in 4 years, and it's probably about the same for me, that I've seen an amount in here. But if you look in the MLS, sellers are still paying buyer's closing costs. You know, maybe $1,000, it may be $6,000, it's just whatever. Buyer expenses, which buyer is prohibited from paying by FHA, VA, Texas Veterans Land Board, government loans. FHA, I don't believe there's anything that the seller's required to pay for the buyer on getting an FHA loan. A VA loan, they are required to pay for the termite inspection report. The seller's to pay for the termite inspection report. Here it goes into buyer's expenses and what they are. I'm not going to read through all of those. I think you guys can get through that. If the expense exceeds the amount expressly stated in the contract for such expenses to be paid for by the party may terminate this contract. Third-party finance addendum is a prime example. If you put that the interest rate will not exceed 2% for your buyer, and the interest rate comes in at 4%, they can have it out. If you put that the fees for closing will not exceed 1%, and it exceeds 1%, and there's certain fees that covers, the buyer has an out. Proration, taxes, HOAs, things like that will be prorated. Even the lease, if it's an investment property and there's a lease, the rent will be prorated. So taxes are prorated from January 1st till the day of closing. Homeowners Association, they've gotten the resale certificate to see if the seller is current, how far they've paid, and if there's an advance that the Homeowners Association wants, then the buyer would pay for that. Any questions on that? Casualty loss, if the house burns down, they got to put it back to the way it was. Or any other catastrophe. After the effective date of the contract, the seller shall restore the property to its previous condition as soon as reasonably possible, but any event by the closing date. If the seller fails, beyond factors of the seller's control, buyer may terminate this contract, may extend, or accept the property and receive the proceeds from the insurance company if the insurance company will allow it. You notice there was a number of times that mentioned paragraph 15. If somebody defaults, if the buyer complies with this contract, if the buyer fails to comply, then the buyer will be in default and the seller can take them to court for specific performance. Now, if they get out during their option period, they're not in default. If they don't qualify for their loan and their third-party finance addendum says they'll have credit approval within 14 days, and notice is given on the 14th day that they don't qualify, they have it out. They're not in default. If it goes to day 15 or day 16, they're in default and they don't qualify. I had one here recently, a townhome, a condo a lady was buying. She had not paid one of her bills. It was like 60 days late. No, it was 30 days late, I'm sorry. And so they pulled her credit report the day of closing, and that thing showed up, and they said, she doesn't qualify. She was in default. Because we were past our finance. We had approval, we had credit approval. They pulled that last credit report, as a lot of mortgage companies do. Boom, that came up. And the lady was like, it wasn't my a whole different story I won't get into. So specific performance can be done, seek such other relief as may be provided by law or both, or the buyer may terminate this contract and receive earnest money as liquidated damages, thereby releasing both parties from the contract. If seller fails to comply with the contract, seller will be in default, and buyer may enforce specific performance as provided by law or terminate the contract and receive the earnest money. So there's that. Mediation. Well, this used to actually be a separate addendum that parties will agree to share in a mutually acceptable mediator and the cost. I've had it happen one time. It was over earnest money dispute. They just split it. Attorney fees, a buyer and seller, seller, listing broker, other broker, escrow agent who prevails in a legal proceeding related to the contract is entitled to recover reasonable attorney fees and all costs associated with such proceedings. Escrow. Escrow agent is not a party to the contract. Just so you guys know, the title company is not party to this contract. And does not have liability for the performance or non-performance of this. If the earnest money is lost in transit from the point they got it to the point it went to the bank and the bank lost it, it's not the escrow title company's fault. Expenses, all expenses, the earnest money, at closing, the earnest money will first be applied to any cash down payment and then to the buyer's expenses, and any excess refunded to the buyer. If no closing occurs, the escrow agent may require a written release of liability of the escrow agent from all parties. Number 2, require payment of unpaid expenses incurred on behalf of the party, and number 3, only deduct from the earnest money the amount of unpaid expenses on behalf of the party receiving the earnest money. For example, if the title company ordered the HOA covenants, restrictions, bylaws, resale certificate, and they went ahead and fronted the money, whatever that amount is, they can pull out of the earnest money. And then the party who gets the earnest money gets it. Well, what happens if the buyer and the seller are playing not nice with the earnest money being released? Upon termination of this contract, either party or the escrow agent may send a release of earnest money to each party, and the party shall execute counterparts of the release and deliver same to the escrow agent. If either party fails to execute the release of either party may make a written demand. The title company will send that demand out. And they have, I believe it's 15 days. The other party has 15 days if there are any objections to this demand. And if nobody responds, then the party that issued that demand gets the money, minus any expenses that the title company may have incurred. Damages, any person who wrongfully fails or refuses to sign a release to the escrow agent within 7 days of the receipt of the request will be liable to the other party for damages, the earnest money, reasonable attorney cost, and all cost of a suit. So it can go to court. Representation. All covenants, representations, warranties in this contract survive closing. This is interesting. If a representative of the seller in this contract is untrue on the closing date, seller will be in default. Let me think of a situation. I'm thinking somehow with an estate. And the seller said, the person that signed the listing agreement said they owned the house, but they actually don't own the house. They made a false statement. They could be taken to court. Federal taxes. You're all going to deal with one of these sooner or later. I've dealt with this one. This is about foreign persons. If you are representing the buyer, when you're representing the buyer, and if you find out that the seller is a foreign person, they're supposed to let you know. It says, if seller fails to deliver affidavit or certificate of non-foreign status to the buyer, that seller is not a foreign person, then the buyer shall withhold from the sales proceeds any amount sufficient to comply with applicable tax law, and deliver the same to the Internal Revenue Service and the appropriate forms. So I had a client one time buying a house in Lake Forest in Round Rock. We did not know until just prior to closing through the title company's research that the seller was a foreign person. My client had to pull out money out of the buyer's proceeds, and the buyer was not happy. And he said, well, I bought this under my corporation, and my corporation, blah, blah. We had to pull the money. We could not take the chance. Otherwise, the buyer would have been responsible for those taxes. So we pulled out, I believe it was 10% out of the thing. It was held in escrow until it was cleared up. If it wasn't cleared up within the time, then the taxes have to be paid, and the Internal Revenue Service has to receive their appropriate tax form.
How did you know how much to pull out? With it,
We got the title company's recommendation
Okay.
on what to pull it, and I believe it was 10%.
So the buyer had to figure that out?
The buyer had to pull that out of the seller's proceeds.
Oh, so they took it from its.
And if the seller hadn't agreed to it, we were going to have a real problem. But my clients probably had a leg to stand on if they wanted to, if the seller did not agree to it,
They could've
they could have gone to paragraph 15 of default, and that it was never delivered of an affidavit. Again, all notices, whether in writing or anything else, go to these things: for the buyer, for the seller, agreement to the parties. These are all the addendums. Are these everything that you would ever see? The answer is no. You might write non-realty item addendum in here. You might write seller's temporary lease in here. You might write buyer's, golly.
we know what you meant, though.
Good, I'm glad. Actually, the temporary leases are, buyer's temporary residential lease is already in here, and seller's temporary lease is already in here. If it's a short sale, there's an addendum in there. Gulf Coastal Waterway, you won't deal with. You know, what we did skip over was that the property, if it was built prior to 1978, and I say even if it was built in 1978, to do the lead-based paint addendum, and the seller is responsible to get that to you. But you need to, if they don't, you need to let the buyer know this is a 1978 home. It could have lead-based paint. And there is a little booklet that you can print out on dot loop that needs to go with that.
As I recall, Avis doesn't want us to do short sales unless it's for designated people, because there's a lot of risk associated with it.
There is a lot of risk. So I was a short sales specialist for a few years back in 2008, 9, 10. I pray to God I never have to do them again. Some of them were easy. You really have to know what you're doing. And you have to speak the lingo. You have to know the phone numbers. You have to know how to turn the paperwork in. And it is intense. You have to qualify with the seller's help to get them to get all their financial statements to the bank so that they can review it, to give permission to do the short sale, on and on and on and on. It's a lot of work.
Back to the foreign owner.
Mhm.
If you're the buyer agent and you suspect that that may be an issue, is that, I mean, are you throwing up red flags early on in the process to ask the seller agent about that?
Not at all.
Okay.
Also ask the title company.
I just think it would be
We would,
potentially a big issue in this area.
we
because-
would not have known if the title company hadn't told us. There's no reason
Well,
that, I mean, we never received anything or any notice or anything like that, that this was a foreign person, anything like that. I mean, it seriously, it was like a day before closing that we found out.
I think it would be a bigger issue around here than people may think because of a lot of the tech companies are here. Samsung, because my
Yeah.
son works there,
Mm-hmm.
they bring people from Korea,
Yeah.
set them up here
Yeah.
for a year or two, and obviously they're just like temporary, there's nothing stopping them from
Right.
owning property.
That's right.
You know, Samsung's just one,
Mm-hmm.
many, so,
Well, this is the only time in 25 years I ever ran into this.
well,
But I was, in 25 years, you're going to hit something at least once, if not 100 times. So,
well, the only reason I asked is, obviously, with everybody thin-skinned anymore, you don't want to throw flags about you're a racist or something,
No, it's, to me, it's not, I hear what you're saying, but you're protecting your buyer so that
Exactly.
the day before closing, we don't find out.
Well, yeah, to me, I'd rather do the legwork on the front.
I mean, the guy owns a corporation here,
Yeah.
all of that. We don't know that he's a foreign person. I have no idea.
You kind of look like y'all sometimes.
Sometimes.
Sometimes we
Yeah, you Canadians. Yeah. Paragraph 23. Remember that I stated where it said that the buyer will take the property as is, or they'll take it as is at seller's expense. Boy, I'm just trying to make that one run-on word. That actually gets trumped. The buyer has the right to have an inspection on the house by a Texas Real Estate Commission person. Okay, that's at the buyer's expense. This paragraph here, for a nominal fee or nominal consideration, the receipt of which is herein acknowledged by the seller, the buyer agrees to pay seller blank amount for the option fee within 3 days from the effective date of this contract. And it grants the buyer the unrestricted right to terminate the contract by giving written notice within so many days from the effective date of the contract, called the option period. Here's what I tell the sellers when I'm going over this offer. This paragraph can be used if they don't like your carpet color, they don't like your paint color, they can just walk within the days specified right there. And they'll give you this amount. They'll give you a check for that amount right there, whatever it is. And then I say, but what most of the buyers use it for is to get their inspection at their expense and to negotiate repairs between the buyer and seller. And I tell the sellers, if you want to do A, B, and C, but you don't want to do D, E, and F, then you have that prerogative to counter back with that on an amendment to the contract, which is separate form. If the buyer doesn't like that, as long as the buyer is within this time frame by 5 o'clock local time, they can terminate with the form.
How many days do you normally put in?
Well, that's a really good question. So the number of days, I can see it anywhere from 7 to 14 days is generally what I see. If it's a multiple offer situation, I see 3 days, I see 5 days, 7 days. If it's around a holiday, extended holiday, you might see these days up higher.
I generally put in 10 days.
Mhm.
I've noticed that the agents in Austin like to go with 7 days.
Yes. Yeah. 7 is kind of what I see the most of on here. Multiple offer, I'll see less days here.
Yeah.
If no dollar amount is stated in the option period, is there an option period? If there's no amount, fails to pay the option fee to the seller within the time stated, the option fee as the option fee, and if buyer, what am I reading, the same line? Yes. This paragraph will not be part of this contract and shall not have the unrestricted right to terminate. So here's what it means. Greg brings me an offer. I'm on the listing end. It is Greg's responsibility to get me that option fee within 3 days per this contract. If he doesn't, there is no option period. If he brings it to me on day 4, is there an option period? You need to talk to your seller and say, they're past their time, they have no right to an option period. What do you want to do about this? I promise you the seller's probably going to say, just sign it. If you as an agent sign this last page, right here, and it's on day 4, or day 5 or day 6, they have an option period. What should you, as buyer's agents, do with the option fee before the 3rd day? Should it go to the title company? Should it go to your broker? Should it goes to the seller? Okay.
Doesn't go to the title company.
It needs to go to the listing agent.
Right.
Yes, it can go to the seller. I will want someone to sign this right here, seller or listing agent. I cannot tell you how many people leave the money, the buyer's agents leave it at the title company thinking, I'm going to go pick it up. I am not going to pick it up. It's their job to get it to me. And they think that's delivering. And I had one that was at a company that's no longer around, Gracie Title. They left the earnest money, the option fee there, and never told me about it. Days go by. Never asked for it, anything. And I happened to be at the title company, and I said, we got an envelope here for you. I don't know what's in it. Open it. It's the option fee. Do you think I signed for it? Had one in Killeen that the agent never brought me the option fee. They sent it an amendment for repairs, and we said, we're so sorry, you have no option fee. You can't ask for repairs. She's like, but. I said, it says it in paragraph 23 if you don't deliver. Well, I never deliver it until the closing.
Closing?
Seriously, that's what she said. She says, I never deliver it until closing. I said, you have no option period, you cannot. And I sent her this wording, and then I sent her some wording off of Trek. Guys, my big point is, do not leave this at the title company. If you have to drive to the listing agent's house to drop it off, and it may be across town, or send a courier or something, but don't leave it at the title company, because all it takes is the agent not to pick it up and to sign for it, and your host, and your buyer's host. And then guess who's going to get in trouble? But you'd be real surprised how many agents leave them at the title company. It's just amazing. But that's not what this says.
Yeah, I've had agents tell me, just drop it at the title company. And I say, no, I need to bring it to your office.
Yeah. I don't care if your broker signs for it. I need somebody to sign this.
When you went to that title company and they gave you that envelope, did you just refuse to take that?
No, I took it.
You took
I put it in the file, but I never signed on that document. I never signed that I received it because it was days out. I mean, it was almost 2 weeks.
So did it go to the seller? That money?
No. I'm trying to think what happened. The buyer ended up, here's the thing, the buyer's always going to be able to find a way out of the contract if you don't take that check. So you got to pick your battles. But this was 2 weeks. But they got out through their mortgage company. So, okay. The option fee will or will not be credited to the sales price at closing. So most of the time this will be credited. What I am starting to see a little bit more of a number hanging around about 250. Unless it's a multiple offer situation, then I've seen this number at 500. I don't know if I've seen one at 1,000. It says, consult an attorney before signing. Trek rules prohibit real estate agents from holders from giving legal advice. And if they want to have an attorney look at it, here's where their attorneys sign it. Once it's under contract, this is where you put the effective date, right here. When is a contract when does a contract go into effect?
The
The last signature. Okay. If the agent calls you and tells you, I got the last signature, it's under contract.
What if they didn't put in the date on the,
Then you need, I would say you need to.
just put what they told you?
Yes. Yeah, I mean, if they called you up on a Sunday and said, hey, everything's signed, that's the effective date.
You know, one time, I had an attorney, who was submitting an offer, and the date, closing date was different than he expected. And he goes, darn it, he goes, now I gotta read this thing like an attorney.
Gosh. Make sure when you put your closing dates in that you look at your calendar to make sure you're not putting it in on a weekend or a holiday.
Yeah.
There's something that I missed that I want to go over. I think I have enough time here. Paragraph 7.
So what if they sign on a weekend or a holiday? You're saying it's just better not to.
Remind me what I said because I forgot.
The execution date, you said don't put it in on a weekend or a holiday.
No, it's fine to put the effective date in.
Closing date.
It's the closing date. I
Oh,
say,
okay.
don't, just make sure.
Yeah.
I had one recently that I did. I just wasn't thinking, and I put the closing date on a Saturday. So we had to get an amendment and change that. One thing that I did forget on paragraph 7, in reference to the property conditions, seller shall permit buyer and buyer's agent access to the property at reasonable times. Buyer may have the property inspected by inspector selected by buyer, licensed by TREC, otherwise permitted by law to make inspections. Any hydrostatic testing must be separately authorized by the seller in writing. Hydrostatic testing is testing the water lines in the house, putting pressure on them to see if there's any leaks. That should be in a separate agreement. The seller is to always keep the utilities on at the house, all of the utilities, even up till the day of closing. So I did skip that.
Is that new, this?
No.
Static, that was in.
Oh, yes, this is new. Yeah. There's the lead-based paint addendum that I brought up. Acceptance of the property as is means that the present condition of the property with any and all defects and without warranty except for the warranties of the title and the warranties of this contract. Buyer's agreement to accept the property as is under paragraph 7D1. Oh, wait, 7D1, right here. And 2, does not preclude buyer from inspecting the property under paragraph 7A, from negotiating repairs and treatments in the subsequent amendment, or from terminating this contract during the option period, if any. What other questions do you guys have for me? Thank you for letting me having you guys be my guinea pig for being the first time. Having to compete with Avis, I'm thinking, oh, I hope I got this covered. And Scott.
You did good.
You did good.
Fine.
Good, good, good.
Thank you
So,
very much.
if you guys ever have any questions, call me. You call me. Greg doesn't call me much, but
Thank you, Dave.
You are so welcome. You guys have a great day.
You too.